you, Mr. Chairman. I think it appropriate to give some indication as to why it's important for us to be concerned about activities of the third-party processors as they relate to the banking industry. And for clarity purposes, these third-party processors, as they are called, are businesses. And these businesses, for a fee, will accept payments from consumers, and they accept these payments, and they give these payments, they deposit them in banks for merchants. And it's a good business. There's nothing illegal per se about third-party processors. There's nothing illegal per se about the businesses that have been mentioned today. But I do think that we have had some things to occur that have caused us to take a look at this process. And quite frankly, I think the American people would want us to look into these things based upon some of the past occurrences. So let's take a look at a few of them. On March the 12th, 2015, and I am not going to mention the name of the banks, but if someone wants me to, I will. But on March 12, 2015, a bank paid $1.2 million in fines, $1.2 million in fines for knowingly facilitating consumer fraud. Consumer fraud, meaning people from our congressional districts were defrauded. It happened. It cannot be ignored. April 2014, a bank, name not mentioned, but available if I need to, paid $1.2 million in fines for fraudulent charges made by a third-party processor. Another fine paid, $1.2 million. March 10th, 2015, a bank paid $4.9 million in fines. The processor was allowed, in this case, to make hundreds of thousands of withdrawals over a 20-month period on behalf of a telemarketing company that charged unauthorized payday loan referral fees. Now, this would give the payday loan industry a bad eye, a bad reputation to allow something like this to occur and not take action. There is no effort on part of the FDIC to eliminate payday lending, but I do think that when we see these egregious circumstances, we have to do something. The banks should not just simply be a party to this by seeing it occur and not do something affirmative to stop it. They are there. They know that these things are going on, and they should take affirmative action. They should have a compliance process in place. And when they do not, I think that that should be called to the attention of banks. And that's really what the FDIC appears to be doing. And here's one. On November 12th, November 2012, excuse me, $15.5 million settlement, 2 million fraudulent charges by a third-party processor. 2 million. These are people who are being hurt. I do appreciate what my colleagues have said about the businesses, and businesses who are operating legitimately should in no way be challenged about what their lawful business operations are. But there's a reason why we are looking into things in this area. And I want to thank you, Mr. Chairman, for the way you have aggressively made an effort to correct mistakes that were made. I have some of your testimony, and you did not go into any great detail, but I would like for you to respond. It appears to me that you participated in a national call with all FDIC supervision staff. Tell us about that call and what you were attempting to accomplish with that call, please.
Well, thank you, Congressman. As I indicated previously, we wanted to be sure that our examiners are implementing the policy that we've announced and clarified, which is that banks are neither prohibited nor discouraged from serving a customer, as long as the customer is in compliance with state and federal law, and the bank has the appropriate procedures and controls. And we established a set of processes for examiners to follow in implementing the policy. I don't want to repeat it all again, but it has to be in writing. It has to cite the regulation and law. It has to be approved by regional directors, and ultimately any actions have to be reviewed by our board. I took part in a nationwide all-hands call with all of our examiners nationwide to emphasize the importance both of the policy and of the importance of implementing the procedures to ensure that the policy is faithfully implemented. And I'm very committed to this. I understand the concerns that have been raised. It's a balance that you have to strike here, that we want banks that have appropriate controls, customers that are abiding by the law to have access to banking services. At the same time, we want banks to have an appropriate set of controls to identify any improper activity that may be going on. So it's a balance to strike. It's what we're trying to do.
You also met with the 6 regional directors. This is something you did yourself to make clear what the policy was in the event someone was unclear. Would you kindly give some intelligence on this?
Yeah, consistent with the call to all our examiners, I met with our 6 regional directors who oversee our examiners around the country, again, to emphasize the importance of and make clear the policy and the procedures that we're implementing to ensure that the policy is followed. I wanted to send that message from me directly, both to our regional directors as well as to our examiners.
You've mentioned it, but I think some things bear repeating. Toll-free numbers that you have made available, at least 2. Would you reiterate, please?
Well, as I indicated, follow-through and implementation is really what's important here. That's the reason for the calls and the meetings and the establishing the written policies. And we wanted to give bankers a recourse, that if they think an examiner is not acting appropriately, not following the policy, not implementing the procedures, we wanted to give them a confidential way to report that. So we provided in our public statement a phone number and email address for our ombudsman, as well as a phone number and an email address for our inspector general, so that any banker that believes an examiner is not doing what they should be doing can report it on a confidential basis. And frankly, I would hope the banker would make the effort to report it to our regional office so that we can act on it directly, but I understand the concern and desire of some bankers for confidentiality, so we wanted to give them an avenue to report the information on a confidential basis.
And the notice process to banks has now been not only formalized, but it's been codified, and you have made it clear that this is to be done in writing. There will be no informal conversations that will be recognized. We all have some people who don't adhere to the letter and spirit of policy, but you have made it clear to people that your expectations are that policy will be followed to the letter and in the sincerest spirit with which the policy was promulgated. Fair statement?
Yes, I think so, Congressman.
Would you want to add anything more to this list of things that you've done to make sure that mistakes are properly addressed?
Just to be clear, that the procedures that you just described, we put in writing. They are public. Our examiners are expected to follow it, and the procedures make clear it has to be in writing. It cannot be in informal communication, and that reputational risk by itself is not the basis for an action. So we've tried to be responsive to the concerns that have been raised.
Thank you, Mr. Chairman. I will reserve my final 5.